It's that time of year again, and by that time of year, I mean the time when artists across the internet come together to participate in daily drawing prompts. I've seen people expressing concerns on Twitter about what the Inktober copyright means, and whether they can even participate this year. The answer is yes, you can still participate. Whether you should participate, though, is a question the internet is still debating. To help you make an informed decision, I'm going to do a bit of a copyright versus trademark breakdown, explain what the Inktober trademark really means, and provide some information about the plagiarism allegations that came up shortly after Inktober was trademarked. Before we begin, a disclaimer. I am a licensed attorney, but this video is intended for educational purposes only and nothing in it constitutes legal advice. If you're having an intellectual property problem, I always recommend you go to a local attorney, someone who can hear the facts of your specific situation.
One more quick disclaimer, because if we lawyers love anything, it's being pedantic and feeling superior, and I don't want to get lawyers in my comments claiming I don't know myself. Throughout this video, I'll be using trademark as a verb meaning to formally register one's trademark. There are nuances to trademark law, especially regarding the formation of trademarks. I'll explain more in the description below, but if you're here to critique me like you're my 1L legal writing professor, I suggest you find a hobby instead. Now let's get back to Inktober.
Too many times now I've seen viral tweets on Twitter claiming that Jake Parker, the creator of Inktober, has copyrighted Inktober. This is not true. He has trademarked it. The terms are often used interchangeably, especially on the internet, but they actually have very different meanings and offer very different protections. A copyright is an original work fixed in a tangible medium of expression. That means it's either been written down or recorded. Examples of things that can be copyrighted include books, art, music, plays, and so forth. Things that can't be copyrighted include facts, ideas, research, and things of that nature. If you had, say, a 31-item long list of random words, that generally would not be copyrightable. Trademarks, on the other hand, cover things like slogans, logos, and names. While the purpose of copyrights is to protect a creative work, the purpose of trademark is very different. The purpose of a trademark is to protect a recognizable brand and to indicate its source. When you all see this cup in my hand, you know right away that it comes from Starbucks. This is because the Starbucks logo is very recognizable, and no surprise, it is trademarked. Similarly, Jake Parker trademarked the Inktober logo, which since Inktober's start in 2009 has become very recognizable. If you're wondering whether I use this video as an excuse to order Starbucks, you are absolutely right. Now, a bit of background. As I just mentioned, Jake Parker started Inktober in 2009. As you can see here, he filed his application in November of 2017, and the trademark was finally registered in October of 2018. This effectively puts the rest of the world on notice that Jake Parker owns the Inktober brand and that he is the source for Inktober, i.e. all official Inktober prompts come from him. Now, what does that mean? It means he has a number of rights to the Inktober logo, one of which includes policing who can use that logo. Coincidentally, this trademark application came right before he was set to publish a book, which I'll discuss more later. Now, in Parker's own words, he registered the trademark to keep bad actors from using the logo in nefarious ways. For example, someone could make a racist t-shirt and put the Inktober logo on it. His example, not mine. But in 2019, it started coming out that artists on Amazon who were just selling Inktober print books were getting cease and desist letters stating that they were infringing on the Inktober trademark. Now, what is trademark infringement? Infringement occurs when unauthorized use of a trademarked logo will result in consumer confusion. In other words, it occurs when consumers might not know the use is unauthorized and will think that the product comes from the original source. The racist t-shirt example would be infringement because there is the potential that consumers might think that Inktober sponsored the shirt and through Inktober, Jake Parker. Now, when the internet got mad about these cease and desist letters, Jake Parker tweeted something along the lines of, "Gah, these pesky lawyers not obeying my wishes." He made it clear in statements afterwards that his intent was never to go after artists, only to go after companies using his logo. He said you can even continue to sell art you made during Inktober, so long as you follow the guidelines that he posted on his site. You may be wondering, is this true? Does following these guidelines really protect me from getting a cease and desist letter? Even if I'm not a company and I'm just an artist, are there ways I might be seeing legal repercussions for participating in Inktober? Here we see a screenshot of the trademark guidelines on the Inktober website. Inktober is free to participate in for individuals. The hashtag is free to use. You can post your Inktober drawings with the word Inktober on it, the logo on it, and with the hashtag on them as well. If you're looking to sell your Inktober drawings using the word Inktober somewhere in the listing, there are some additional guidelines you need to follow. Now this seems pretty cut and dry, but it leaves out certain situations. And that's where knowing the purpose of trademark protections comes in handy. For example, can you create your own prompt list and call it Inktober? Well, if the purpose of trademark protections is to identify the source of a good, you creating your own prompt list and calling it Inktober could be muddying that source and causing consumer confusion. So doing so might open you up to legal repercussions from the owner of the Inktober trademark. One of the interesting things about trademark law is that if you don't enforce your trademark, you might be at risk of losing it. For example, famous marks can be diluted through something that we call tarnishment. This is when a registered mark is affiliated in one way or another, usually unofficially, with a trademark that's seen as unseemly or inferior. Now, I personally love all the creative Inktober variations that I've seen around the internet, even the not safe for work ones, but one example of this could potentially be Kinktober. Some might see that as an unseemly affiliation, especially because the name Kinktober is so similar to Inktober. And you can also lose a trademark if it becomes too generic. One famous example of this is Google. We say, I Googled this, go Google that, when we really just mean look it up on the internet. This also happens every time we refer to off-brand bandages as Band-Aids, or to tissues as Kleenex. The lawyers over at Velcro actually made a whole music video about this.
This part's a hook, this part's a loop.
So you could make the argument that every time someone creates a non-official prompt list and calls it Inktober, they're weakening the Inktober trademark. You might be saying, you lost me at trademark dilution and genericide, but there's a reason this is important. If every new prompt list that gets posted calling itself Inktober weakens the actual Inktober trademark, Parker might have reason in the future to enforce his trademark rights against those prompt creators. One valuable way that you can protect yourself is by naming your prompt list something other than Inktober. Instead, you can follow in the footsteps of challenges like Spooktober or Kinktober or even Flowertober. If you are still planning on participating in Inktober, and especially if you intend to sell the art you make during the challenge, I recommend checking out Parker's website and the guidelines he posted for using the Inktober name. I've included this website in the description below. Now, I promised I'd touch on the plagiarism claims. In 2020, 2 years after Parker registered the Inktober trademark, he published a book called Inktober All Year Round. Artist Alfonso Dunn responded by posting a video here on YouTube, alleging that Parker plagiarized his pen and ink drawing book, which was published in 2015. In his video, Dunn goes through both books, including illustrations included within the books, and points out the similarities between the two. I've included a link to both the video and a buy link for the book below. If you're looking to improve your art, I highly recommend checking out the pen and ink drawing book. It is such a great resource for artists, and if you watch Dunn's video, you'll see just how much work went into creating that book. Now, I won't go into the merits of the plagiarism allegations, but I recommend you check out Dunn's video and let it speak for itself. I will say he spends 50 minutes going through both books cover to cover, and there are a lot of similarities. It's worth noting that Parker is completely within his legal rights to enforce his trademark. The question seems to be whether he has a moral obligation to the artists and the fans that made Inktober what it is, not to enforce that trademark against them. Inktober is unique in that it's a collaborative experience inviting participation by individual artists. It was sending those cease and desist letters that brought this issue to the light and caused so much anger on social media. So is the problem in registering the trademark, or is the problem in enforcing it? Now, whether Inktober is copyrighted or trademarked, whether Parker means what he says about only going after companies and not artists, fans and artists across the internet have expressed hurt over the registration of this trademark. From its start, Inktober has been more than just a list of prompts. It's been a unifying, collaborative community experience. Maybe that's what sets it apart from its writing counterpart, National Novel Writing Month, which actually owns several trademarks but hasn't gotten any of the negative attention. Of course, I've never heard of Nano sending cease and desist letters to its authors, whether accidental or not. Artists have always felt like they were a part of Inktober, like it belonged to everyone in the community and not just one man. Jake Parker registering this trademark is, in a way, a betrayal. It's a reminder that no, you don't own Inktober. You can only participate in it because I put out the prompt list each year. Of course, the internet responded with an explosion of creativity, the generation of dozens and dozens and dozens of new prompt lists with dozens and dozens of unique themes. Finding an alternative to Inktober is as easy as opening up Twitter, and you can find one that tailors to your unique taste and follows a theme that you're really excited about. If you found this video interesting, be sure to hit like and subscribe below. If you have any questions on copyrights and trademarks, leave them in the comments and I might address them in a future video. I'm an intellectual property attorney, but I'm also an author and artist myself. I know how tangled the legal world can be, and I have lots of videos planned that I hope will help untangle it for creators like you putting your works out on the internet.